Today I am going to talk about the sources of Hindu law. Hindu law is made up of various texts and scriptures. The growth of Hindu law was both natural and sometimes helped in by the legislation that was enacted during the British period. Sources of Hindu law can be divided into ancient sources and modern sources. Ancient sources include religious texts such as Shrutis and the Smritis. Apart from that, there are various Upanishads which also were a part of Hindu law. Shruti as a source of law. Shruti means to hear. It is derived from the word sur, which means to hear. Shrutis are considered to be major source of Hindu law. Another term of Shruti is Veda. According to Hindu law, there are 4 Vedas, namely Rig Veda, Sama Veda, Yajur Veda, and 4th one is Atharva Veda. The Brahmins used to pronounce what is written in these Vedas to the people. Since Brahmins were considered to be knowledgeable people, whatever they said was of supreme importance, and it was considered to be the law of the land. Therefore, Shrutis contain what is written and pronounced by the Brahmins. Brahmins also tells us about the duties that the individual has to follow and how to perform these duties. The Upanishads contain the essence of these duties. Smriti as a source of law. Smriti is derived from word smri, which means to remember. Smritis are those parts of Shrutis which the sages forgot to tell in their original form and therefore wrote down in the language which they were familiar with. Therefore, Shrutis are considered to be the basis of Smritis. There are 2 kinds of Smritis. First is Dharma Shastra and the other is Dharma Sutras. Dharma Shastras contain the rules regarding the moral code of conduct for Hindus, whereas Dharma Sutras contain the rules regarding government, caste, the relationship between people, economic affairs, eating habits, etc. There are many Smritis that one cannot count, but the 2 famous Smritis are Yajnavalakya Smriti and Manu Smriti. Manu Smriti is also considered to the first law book written by Manu. Digests and commentaries are also the source of Hindu law. The 3rd most important source of law is the digests and commentaries written by various authors of Hindu law. Commentaries generally comment on the Smritis. The area of commentaries is from the 7th century of 18,000 AD. Commentaries also laid the foundation of various schools of Hindu law. Digests contain the important aspects of all the Smritis and discuss their reconciling and contradictions. Various digests and commentaries have been written by various authors on the 2 most famous Smritis, that is Manu Smriti and Yajnavalakya Smriti. So namely are Manu Smriti, Medha Tithi, which was written by Manubhasya, Govind Raja was written by Manuka, and Vigneshwara was famous commentary on Mitakshara. Arpaka has been written by Aparaditya. Customs are the most important and the oldest form of lawmaking. Custom means the traditions, practices, activities that people have been following for generations and over time recognized as law. The essence behind considering customs as a major source of law is that since people follow customs and if some customs are not harmful to society, then the state has no problem recognizing it. In order that a custom becomes law, there are some essentials that it may fulfill, such as a custom must be valid, it should be a continuity, and it should be followed by a large number of people, and last, it must not be discriminating and should not be opposed to public policy. India has recognized 3 types of custom, namely local customs. These are prevalent in the particular local areas. Class customs. These are the customs that is prevalent amongst a particular class. Family customs. These are customs that are binding on the members of the family. Modern sources of Hindu law. After the arrival of British, many changes were brought and in the personal laws of Hindus, and many legislations were also passed. The modern sources of Hindu law, the doctrine of justice, equity, good conscientiousness, legislation and precedents. Justice, equity and good conscientiousness. In such cases, there are no proper law to settle the disputes, nor there was any existing law. Then the judges used to give judgments according to the concepts of justice, equity and good conscientiousness. This doctrine was based on the concept of fair play. This doctrine did not have a uniform application, since thinking of one judge may be different from the other. However, this doctrine played a huge role in transforming the personal laws of the Hindus. Legislations. The legislation means the acts of parliament. Various acts were passed by the legislature, such as Child Marriage Restraint Act 1929, Hindu Succession Act 1956, Hindu Marriage Act 1955, Hindu Minority and Guardianship Act 1956. The legislation passed is binding upon all the other sources of law. Legislation is codified. This means it has been written in proper way and it has to be accepted and followed by all people governing it. In modern times, legislation is also called as a law-making body. Precedents. After the establishment of British rule, courts were established and the hierarchy was introduced. Precedent means following the decision of the higher courts by the courts below it. If a particular case has already been decided, it seems reasonable to follow the same decision if the facts of the case are similar to the decided case. In today's time, the decision of Supreme Court is binding on all the made by the other courts. So this was it, wherein we have understood the sources of Hindu law, and then we will be coming up with the next topic and we'll be discussing furthermore about family law. Have a nice day.